circumstance is reasonable belief. Community caretaking is probable cause. And for community caretaking, they have to show that these officers believe that there was an ongoing emergency and a danger to the public. There is clearly no testimony that they believe to that. And the deputy testified he did not ask for consent before he started digging. So there could be no consent to that portion. We conceded in our
would consent to access to the premises have to be to every act?
yes, the officer has to operate.
What I'm asking is, if you give me consent to go into the house, I don't have to get separate consent to enter the kitchen as opposed to entering the bedroom. Right.
That is correct, Your Honor. And now consent, now he's now dead, not on the court anymore. Now, I didn't agree with a lot that Justice Andrew Scalia said, but he was not a fan of consent.
Yeah.
I actually am.
That Mr. Johnson is going to quote Scalia. Go ahead, sir.
And the aspect that he was not a fan of consent because he didn't really believe that suspects could ever really consent to armed police officers. But he and the courts have always kept consent and made it very narrow and tight, that an officer has to have consent for the specific actions that they are engaging in. I agree with you. If an officer asks me to search my home, that includes the bedroom and the kitchen because I can revoke the consent at any time. But if an officer asks me to search my home and then the officer then goes into the backyard and starts digging up, engaging in action that he has not asked for permission to do, then that would be outside the scope of consent.
Yeah, but hold on. That's not what happened here, though, because the officer never leaves. The officer is, it's not as though the officer was in the house, got consent to do something in the house, then walked outside and just went to the backyard. They had already been through the backyard, had gone through. So this was, where are you saying, if this court believes that there was consent not only to search the house, but also to search the premises, where are you saying that consent ended?
It is
where they needed additional.
Yes. I concede there was consent to search the house. There was never any testimony of consent to search the yard or the structure that was in the yard. It is our position that the deputy needed additional consent.
Why would he have needed additional consent? Because when they're in the home, they all leave the premises and start walking around the outside of the premises into the yard, right? So you're saying that once he's in, then they come out, that he has to have some separate consent
to dig in the backyard.
Well, no, because once he's there, the digging would be like searching the house and moving a board, and all of a sudden you see something. The issue of consent, I'm trying to figure out where you're saying he needed additional consent.
He needed additional consent to search the yard. He had permission to search the home. He did not have permission to search the yard. And it's our position that the deputy knew it. That's why he didn't ask. He just went back there and started digging. He didn't even ask for permission to search the yard. And we believe.
But if the deputy believed he already had consent, of course, he wouldn't ask again necessarily, right?
Well, he didn't testify that he believed that he already had consent. So, I mean, that I guess that's something the court will have.
Well, the actions of what happening are a continuation. If one believes that consent was originally given, that he's walking around with the individuals that are giving him that consent. I mean, he's given a key, go into the premises. The three of them are there. The three other individuals
are in the house, yes.
In the house, but ultimately they're all outside, right? And then there is this searching around the premise.
Right, they're not all outside at the time of digging. They're, based on the testimony, and it is our position. The only person that had authority to grant consent was Mr. Fleming Jr. We do not believe that there's facts in the record that would establish by probable cause that this officer could have believed that anybody else had the apparent authority to grant him consent after the moment he discovered that Mr. Fleming
I
was the person.
wouldn't I believe that a person who hands me the key to the premises has the apparent authority to give me consent to search. Why wouldn't I believe that? Why wouldn't that be a reasonable belief?
Your Honor, people give keys to neighbors or family members for, all kind of emergency reasons. That doesn't mean that they
Yeah,
can.
but that as to whether or not that person, there's a difference between whether or not that person exceeded their authority and whether or not the person who is sort of believes they have consent reasonably believes under the circumstances that this person can grant consent for me to search.
And Your Honor, I think we are, we getting off. We're in separate lanes. We've conceded.
Oh no, I know we're in separate lanes.
We've conceded the initial entry into the house was based upon the apparent authority of a woman that was there. Okay. Once the deputy discovered that the only person that lived there was Ronald Fleming, then the apparent authority of anybody else there has now been dissipated. There's only one person who would have standing to grant a search under those circumstances. Now we can get into.
I'd like Olson case law on that because I don't think that's true.
Minnesota v. Olson
comes in. The deputy comes into the home. He's searching. I find somebody there. Somebody says they live there. You're saying at that point the consent terminates?
Yeah, what I'm saying is the apparent authority terminates. Remember the testimony. The officer didn't ask these individuals any questions to ascertain whether or not they had any legal standing in that location. The only person, based on the testimony, that had legal standing in that location was Ronald Fleming Jr. I'm surely under Minnesota v. Olson, I don't think there's any argument the government could make and that the court could accept that Ronald Fleming Sr. or this other woman had standing at that location. So now we're looking at who had the apparent authority to grant the second consent search.
But why was the second one needed?
Because the search had terminated. The first search had terminated.
Yes, they hadn't left the premise. I mean, where are you saying it terminated?
When the deputy does not find Deidre, comes back out with Mr. Fleming Jr., and he's given that testimony about him being outside for some period of time, talking with the family, before he asks again if he can go search. It is our position that that second entry was not an exigent circumstances search. It wasn't even a community caretaking search. It was simply a consent search. She was not there. There was no reason for him to believe that she was inside that home and needed aid. But he had consent to search the home, which at that point was given. We are not contesting that. The issue here is the scope of that search. The scope of that search did not exceed to the backyard.
But the problem is that problem with that analysis is the individuals, it's the officers acting, the individuals who have granted him the consent as they're going around are the same individuals that are going around the backyard with him. That's the problem or the trouble I guess I'm having with your argument. It's not as though he had never gone into the backyard prior to that. That's not what happened here. That initial search, you'd have to show me something that initial search, that consent that the officer was acting under only included the physical structure of the house and didn't include the outside, because the factual circumstance of this clearly in my mind indicate there was also this consent to search the entirety of that premise.
Now, with that concept, it is our position that the courts of higher jurisdiction have taken a separate position that the court has taken. It is the position of the government to show that the consent was valid, what the scope of the consent was, and that the officers acted within that scope. It is not my burden to establish in a warrantless search that the government acted outside the scope.
Oh, but here's but I understand that part of the argument, but you're saying that at some point it ended or didn't include the outside of the premises.
Exactly.
And I'm asking you, when did that happen? I'm stating what the facts are as I see them, and that is that there was the inside, there's the outside. They're all going around the premises. At no point did that search stop.
Well, I guess that makes it easier for me. So under the case law, the court has to ask itself three questions. Did the officer ask anybody with standing to grant permission to search that backyard? The answer to that question is no. Did the officer have a search warrant to search that backyard? The answer to that question is no. And so now is that the consent is ambiguous, or there's an ambiguity in the consent of who has the burden of showing that the officer's actions were within the scope of that consent, and that is the government. And here,
you're saying that when they first come to the house, someone hands him a key, the officer goes in, that even apparent authority to the apparent authority that person exhibits granting consent at some point just disappears?
absolutely. My sister has a key to my house. She hasn't heard from me.
Can't or my both can be true, Mr. Johnson. One can have apparent authority grant that consent, but also there be another person that can grant consent. It doesn't make the other, it doesn't negate the other. Both can be true at the same time. Can't they?
I don't I don't think so, Your Honor. My sister has a key to my house. She calls the police and says, I haven't heard from whomever that lives at this residence. I'm giving you permission to enter. The police enter the location. They see me there. I live there. At this point, no reasonable officer could think that my sister, who doesn't live there, has the apparent authority to continue to grant searches at that location when an individual who lives at that location is actually present.
But okay, but but isn't that dependent upon what one's searching for?
No, Your Honor, the emergency aid exceptions made that clear. The heightened or crime that is suspected or the type of emergency that is suspected has no bearing because the courts of higher jurisdiction have always been clear. Go get a search warrant. There is no reason why this officer could not have radioed in and said, hey, been called out here for a welfare check, not find anybody. These are my levels of suspicion. I need a search warrant to search the entire premises.